everyone. Good evening to all the participants here from both India, as well as I can see there are some participants from outside India as well. Thank you so much for taking the time to join this webinar. My name is Renuka Abraham, and I'm part of the Healthcare and Life Sciences team at Spice Root Legal. Today, as you know, we are going to be discussing about the laws regulating surrogacy in India and also certain intricacies and challenges which are associated with regulating surrogacy. The primary reason why we thought it was important to conduct a webinar on surrogacy is because last year, towards the end of last year, we had also conducted a webinar on IVF regulations in India. And continuing with that series, there's a lot of misconceptions and confusions between IVF and surrogacy, and we wanted to eliminate that. For example, the regulations that govern IVF and surrogacy are different. IVF is regulated by the Assistive Reproductive Technologies Act of 2021, while surrogacy is regulated by the Surrogacy Act of 2021. Also, the procedure that goes into IVF and surrogacy are different. IVF as a procedure involves an egg and a sperm being combined outside the body in a lab, and once the embryo is formed, then it is injected into the woman's body, most likely the female of the intending couple itself. While in surrogacy, another third party or the surrogate woman is used to carry the baby for the intending couple. Now, coming back to surrogacy, surrogacy in India has been practiced since the late 1970s, and India was also once called as a surrogacy capital of the world. However, the concept of rent a womb, as surrogacy was famously called as, mistreated and exploited women. So it became important for the regulators to regulate surrogacy in India, and it was finally in 2021 that the Surrogacy Act was implemented. Before we start, let me give you a quick introduction to the firm and the panelists. Spice Root Legal is one of India's leading law firms, and we are a full-service law firm. And one of the sectors that we focus on is healthcare and life sciences. And within this sector itself, we do a wide range of work, from commercial and regulatory assistance to even transactional matters. So along with me, the panelists for today's webinar are my colleagues, Himanshu, Vinita, and Rahul from the Healthcare and Life Sciences team at Spice Root Legal. Before we begin, just wanted to bring to your attention that if you have any questions, there is a Q&A box, and please add in your questions there, and we will address these questions either as we go along or at the end of the webinar. So to give a brief introduction of what we will be covering today, we will be looking at the legal framework of surrogacy, what it was before the regulation was brought in, after the regulation was brought in, and also a quick look at the foreign direct investment policy governing surrogacy. Today, the webinar will start with understanding what is surrogacy, and my colleague Himanshu will take over. Over to you, Himanshu.
Thank you, Renuka. So let's talk about pregnancy. It's this incredible journey, but as amazing as it is, it can also come with its fair share of challenges. Sometimes things don't go as planned, and that's where alternative options like assisted reproductive technologies come into the picture. Now, you've probably heard of IVF. It's pretty common, but there's also a whole range of other techniques like intracytoplasmic sperm injection, controlled ovarian stimulation, cryopreservation, and of course, surrogacy, which is our main focus for today. Surrogacy is a game changer in the world of reproductive technology because it's all about one woman carrying and delivering a baby for another individual or couple who's facing fertility challenges. So first off, there are two main types of surrogacy, each with its own quirks. Firstly, there's the traditional surrogacy. This is where things get a bit more old school. In traditional surrogacy, the surrogate mother actually uses her own egg to conceive the baby. It involves artificial insemination, where the sperm of the intended father or a donor is used to make it happen. And the next one is Gestational surrogacy. Now, this is the one that is a bit more modern and widely preferred as well. In gestational surrogacy, the surrogate mother carries a baby that's been conceived using an egg from the intended mother or maybe even an egg donor. And it's pretty neat because it cuts out any genetic ties between the surrogate and the baby. Now, back in the early 2000s, India became a hotspot for non-residents looking for gestational surrogacy. Well, mainly it was because it was way more affordable compared to Western countries that attracted intended parents facing financial barriers to surrogacy. Plus, India had top notch medical and technologically skilled doctors as well, and also not too much of red tape to navigate through as well. So, and also, let's not forget about the abundance of surrogate mothers ready to lend a helping womb as well. So it took off in India, especially when celebrities like Shah Rukh Khan, Karan Johar, Shilpa Shetty, to name a few, opened up about their experiences with surrogacy, and it kind of put surrogacy in the spotlight, and it made it more accepted across the country. But then things started to change. There were concerns about the ethics of commercial surrogacy and the possibility of exploitation. So India decided to shake things up with some legal reforms. They put the brakes on commercial surrogacy for foreign nationals and shifted towards a more altruistic arrangements. That meant no more paying surrogate mothers for their services. Now, with the recent legal changes, international India for surrogacy options. But here's the thing: despite these hurdles, surrogacy agencies and clinics in India are getting creative, shifting to more altruistic setups to keeping things ethical. And India has medical prowess. I mean, we are talking top notch medical facilities, super skilled professionals. I mean, there's a reason why people flock here for medical surrogacy. Between 2006 and 13, India was the surrogacy capital, with thousands of arrangements every year, half of them for foreign couples. And the market here was valued at around 375 million before these legal tweaks. Now, well, mostly because India offers competitive prices, like I mentioned before, compared to places like the US, where surrogacy costs could skyrocket. Plus, our medical infrastructure is second to none. And let's not forget about the booming healthcare sector as well. The government is pushing for digitalization and growth, and we're looking at some serious contributions to the economy. All in all, India's surrogacy game is all about affordability, top notch care, and growing reputation as a global healthcare hotspot. Next up, I'll hand it over to Renuka to take us through the Indian regulatory framework on surrogacy.
Thank you, Manshu. So today we'll be covering the regulatory framework around surrogacy from two separate eras, which is the pre-2021, what was the regulatory landscape in India, and post-2021. So to start with pre-2021, it was first in 2005 that the Indian Council of Medical Research and the National Academy of Medical Sciences introduced guidelines to regulate commercial surrogacy in India. But because they lacked enforceability, because they were only guidelines, it still left surrogate mothers vulnerable to exploitation. So in 2007, one of the most landmark judgments in surrogacy in India, which is a baby Manji case, was brought in front of courts, and the importance to regulate commercial surrogacy was finally discussed. So to go into the facts and the decision in brief, a married Japanese couple engaged an Indian woman for commercial surrogacy in India. The father's gamete was used, and the Indian woman's egg was used for giving birth to the baby. But before birth of the child through surrogacy, the couple unfortunately divorced in 2008. And the wife claimed that because she did not have any legal ties or even biological ties to the baby, she did not want the child, and the father agreed to take custody. But unfortunately, the father had to return to Japan because of some visa issues that he had for staying back in India. An NGO in India filed a PIL with the High Court of Rajasthan, where they challenged the legality of surrogacy in India. In response, the paternal grandmother of the baby filed a PIL in the Supreme Court, where she said that the surrogacy contract that they had entered into was valid and legal, and the baby was actually her grandchild. Interestingly, the Supreme Court also at that time agreed with the grandmother and held that the surrogacy contract was valid in law, and ultimately the custody went to the grandmother. But even at that time, there was still widespread exploitation of women in India. So finally, in 2009, the 228th Law Commission report came up with a recommendation that said that, like Himanshu mentioned, altruistic surrogacy, which is surrogacy without pay, should be allowed, while commercial surrogacy, where compensation was paid to the surrogate woman, that should be prohibited. And finally, it was in 2016 that the surrogacy bill was introduced. And because this was only a recommendation by the Law Commission report and the surrogacy bill was only a bill, many people, including many celebrities in India, did carry out surrogacy as recent as 2021. In this chain of discussion, another important aspect to keep in mind in before 2021 is what was the regulation that permitted foreign couples or even overseas citizens of India to avail surrogacy in India, considering the baby Manji case. The Ministry of Home Affairs, through various circulars between 2010 and 2014, actually did permit surrogacy related visits to India and also granted visas at that time. But because of the developments of commercial surrogacy in India, in 2015, the MOHA ultimately withdrew the permission granted to foreign nationals to avail surrogacy in India, and also all permissions previously granted were also cancelled. But in contrast, interestingly, while foreign nationals cannot avail surrogacy in India, there are no regulations that prohibit Indians to avail surrogacy abroad. In the next part of the webinar, we look at the position after the 2021 Surrogacy Act was passed, and my colleagues Vineeta and Rahul will take over from here.
Thanks, Renuka. So the Surrogacy Act establishes clear parameters for surrogacy arrangements, ensuring legal protection, and the eligibility criteria for the parties involved. Let us begin to understand what are the eligibility criteria for a woman to qualify as a surrogate mother. Now, as my colleagues discussed, the social stigma and multiple health complications were two of the major hurdles that were faced by surrogates in the past. The present eligibility criteria is structured in such a manner that it focuses more on the health and well being of the surrogate mothers and aims to tackle the problems faced in the past. For a woman to qualify as a surrogate mother, she must be between the age of 25 to 35 years. She must be married and have a child of her own. She should be with her husband during the term of the surrogacy process. The Act also mandates that a woman will act as a surrogate mother only once in her lifetime. Now, on fulfilling this criteria, the woman is required to undergo certain medical checks. These checks are done to ensure that she is medically and psychologically fit to act as a surrogate. After this, she will undergo a counseling session with a medical practitioner who will tell her about the nitty-gritties of the surrogacy procedure, the risk, the side effects, and any other complications that would arise. After being aware of the risk, the surrogate mother is required to give her written and informed consent in a language that she is comfortable with. She can take back this consent at any time before the implantation of the human embryo in her womb. Now, it is important to note that a surrogate mother will only lend her womb to the intending parents, and her gametes or her eggs will not be used in the process of surrogacy. Now, since we are on the topic of using gametes in process of surrogacy, let me tell you about an interesting update. So previously, the surrogacy framework required that the intending couple uses their own gametes, which meant that in cases where one partner faces certain fertility issues, the couple couldn't opt in for surrogacy. There were several cases in different courts that challenged this requirement, and finally last month, the central government amended the surrogacy rules. The surrogacy rules now allow couples to use donor gametes, but at least one gamete from the intending couple has to be used during the process. Now let's move on to understand the eligibility criteria for the intending parents. So, for a single Indian woman who is between the ages of 35 to 45 years, she can opt in for surrogacy in cases if she is widowed or she is divorced. Similarly, a heterosexual Indian married couple where the wife is between the age of 23 to 50 years and the husband is between the age of 26 to 55 years can opt in for surrogacy in cases if they don't have a child, or if they do have a child, such a child is either specially abled or unfortunately suffers from a life threatening disorder or a fatal illness that has no permanent cure. So, the eligibility criteria under the Act is limited for intending parents. While India has opened its doors of acceptance for non binary couples, same sex couples, live in couples, as well as single parents, the doors of experiencing the joy of parenthood through surrogacy is unfortunately not opened for them yet. This is also one of the major contentions in a case before the Supreme Court, where several provisions of the Surrogacy Act are challenged. So, while we still await the final judgment in this case, the government, in its affidavit to the court, stated while live-in couples and same-sex couples have been decriminalized, they've not been legalized yet. The government believes that allowing such couples to use surrogacy might lead to misuse of such facilities, and it will be difficult to ensure a better future for the child. Now, it is important to note that globally, the number of countries that are legalizing surrogacy for same sex couples is on the rise. Some of them include Ukraine, Georgia, Belgium, Netherlands, Canada, and even states like California, Illinois, and Nevada in USA. Now, let's come back to India. Very recently, a 44-year-old unmarried woman wanted to opt in for surrogacy. She approached the Supreme Court, but the Supreme Court refused her plea, stating that bearing a child outside marriage is an exception rather than a rule in the Indian society. The court took a conservative view and held that the institution of marriage needs to be protected and preserved, and therefore unmarried individuals cannot opt in for surrogacy in India. Now, this this helps us understand that the legal landscape surrounding eligibility criteria is constantly evolving. Each new case, each new judgment helps us understand the eligibility criteria better, as well as the intent of the legislature. So let's move on to understand the other requirements that the parties have to fulfill. These requirements are in the form of documentations and certifications that would later be stored as records. The first is a certificate of medical indication that basically states that the intending couple or the intending woman cannot conceive a child because of a medical condition, and that gestational surrogacy might be a suitable option for them. The second is an order of parentage and custody of the surrogate child. Now, this document is very important because it acts as a birth affidavit of the child and can be instrumental in negating all issues that may arise regarding the legal parentage and the custody of the child. The third is an insurance coverage for 36 months for the surrogate mother. This insurance will help support the surrogate mother not only during the term of her pregnancy, but also in cases where any postpartum complexities arise. Lastly, a certificate of essentiality will be issued after completing all the requirements. This certificate will act as a final stamp of approval through which parties can commence their journey to parenthood. Now, my colleague Rahul will discuss some other important facets of the surrogacy framework. Over to you, Rahul.
Thanks, Vinita. So, as my colleague Vinita has very detailed explained what the eligibility part under the surrogacy regulations are, we can now examine the why. That is, on what grounds can one actually opt for surrogacy. So, just to give a brief background, before the 2021 regulations came into force, there was no specific requirement of having a reason to opt for surrogacy. So couples, if they wish to, they were free to do it without any restrictions. But now, post 2021, the situation has considerably changed. So the current surrogacy regulations, they provide for a specific list of medical reasons. And only if the intending woman or the wife of the intending couple, if she is suffering from any of these medical reasons, is surrogacy permitted. So we look at all of them in detail. Now, the first one is uterus related issues. So there can be a situation where the intending woman is suffering from any uterus related issues that are preventing her from carrying the pregnancy. Maybe there is a situation where she is missing a uterus. Maybe the uterus has had to be removed due to medical reasons. Maybe there are instances where uteruses have been removed due to gynecological cancer and to prevent a spread of gynecological cancer. So in all such cases, if there is a specific uterus related issue, you need to opt for surrogacy. Now, the second reason I would say it is failed IVF. So as we all know that there are many instances where the IVF treatment, it tends to be unsuccessful. It doesn't have the desired result. So if the intending woman has gone through multiple IVF sessions without success, then the surrogacy rules permit such a woman to opt for surrogacy. Now, the third case where the intending woman can opt for surrogacy under the rules is if she has suffered multiple pregnancy losses. Now, these pregnancy losses can happen due to maybe any unexplained medical reason, maybe due to an exaggerated immune response during pregnancy. Whatever the reason may be, as long as there is a specific medical reason that is causing her to suffer these losses, then the woman is free to opt for surrogacy. A very important element of the question that comes up is what quantifies as multiple. Now, this is where there is an issue currently. So the surrogacy rules, they don't define or quantify what the term multiple will be. So we still do not have proper clarity as to how many pregnancy losses does the intending woman or the intending woman actually have to suffer in order to be eligible for this for surrogacy under the rules. And we hope that the central government maybe in the future will give some more clarity on this aspect, because that will just make the process a little easier. Now, the last reason under the surrogacy rules under which a woman can opt for surrogacy is illness-related issues. So if the intending woman is going through any illness or she has gone through any illness in the past as well, that makes it impossible for her to carry the pregnancy to viability. Maybe the pregnancy is becoming life-threatening for her because of the illness. So in all such cases, surrogacy is definitely permitted. So as we can see, except these 4 rules currently, the intending woman or the intending couple are now not allowed to opt for surrogacy. Can you have the next slide, please? Yeah. And other important part, a very important part, I would state, of the surrogacy regulations is this list of prohibited actions that has been provided under Section 3. Now, this list is basically given to ensure that the real goal of the law is achieved. And as we have discussed, that the main goal of law is to ensure that the surrogacy is undertaken for altruistic purposes. It's become the defining feature of the law. So for the first thing that has been strictly prohibited is commercial surrogacy. Even promoting or advertising the commercial angle of surrogacy in any form is now strictly prohibited. Another thing related to commercial surrogacy is the commodification of surrogacy services and procedures. Now, that has also been banned. So things like buying or selling of human embryos or gametes, offering monetary incentives to surrogate mothers, inducing women to act as surrogate mothers, all of this falls under the broad head of commodification and now is completely banned in India. A very important thing now is that the surrogacy rules also have provisions relating to protection of children who are born out of surrogacy. So the first thing they have done is prohibit surrogacy for exploitative purposes. So for example, if the surrogacy is being undertaken to raise a child for human trafficking, for begging, for child labor, for prostitution, so any such exploitative purposes, surrogacy is strictly prohibited. Also, an express prohibition has been provided for sex selection during the surrogacy procedure. As we all know that India still has some strides to make with respect to that demand, that desire for the male child is still very prevalent. Female feticide is still very prevalent in India. And of course, the government has taken various steps to address this issue. There is a change in society that is happening right now. And prohibition of sex selection during the surrogacy process is just a step forward in that same direction. Another important part is that has been prohibited is the storage of human embryos and gametes. Now, this has been done to ensure that people are not exploited for their gametes, which is then eventually used in a surrogacy procedure. Now, the last thing that has been prohibited is abortion, is procedures relating to protection of the surrogate mother. So the first thing that has been prohibited is abortion without the surrogate mother's written consent. If the abortion is done with her consent, it is only to be done in accordance with the Medical Termination of Pregnancy Act. So this Medical Termination of Pregnancy Act is basically the law that governs abortions in India. Another very important act that has been prohibited is abandonment of surrogate. So what the reason for this to be specifically introduced is because what used to happen before is that intending couples would just change their mind about the surrogacy and they would just disappear. Like they would cut complete contact with the surrogate mother, and that would leave the surrogate mother in a lot of distress. She would be absolutely helpless. So in order to ensure that she's not abandoned throughout the course of the surrogacy until the birth of the child, the Act has an express prohibition on abandonment of a surrogate mother in any form. Now, in order to make sure that these prohibited list of actions is actually followed, the Act has very strict penalties also involved. So if anyone is found violating any of these prohibited list of actions, they can be subject to up to 10 years of imprisonment, and a monetary fine up to 10 lakh rupees can also be imposed. So as we can see, this list is quite exhaustive, this prohibited list. And it is aimed at not only achieving the ultimate goal of promoting altruistic surrogacy, but also protecting all the stakeholders who are actually involved in this journey. Now, as we have already discussed before, the Surrogacy Regulation Act, it is protecting a lot of stakeholders. And one such stakeholder that has to be specifically governed are the surrogacy clinics and hospitals. So in addition to overseeing these legal rights and responsibilities, the Act also has comprehensive guidelines and standards for operation of surrogacy clinics. And this is basically done to ensure that only the best facilities are available for surrogacy in India. So the Act has very strong registration and inspection requirements, documentation requirements. I will just cover that in brief. So the first is a registration requirement. Basically, every surrogacy clinic or hospital who is undertaking surrogacy services, they have to be registered under the Act. Now, this registration, it does not come easy. A thorough review of all the different aspects, the inspection that they undertake before the registration, they look at various different elements, and only if the clinic is meeting the specified requirements is this registration granted. The certificate of registration, of course, is valid for a period of 3 years only, and it has to be renewed. So basically, the entire process of inspection before the registration is granted, it is retaken again, and only if they feel that the comprehensive guidelines, they are continuing to meet those guidelines, is the certificate then again given. In addition to the registration requirements, the clinics also have to maintain relevant records for an extended period of time, for a period of 25 years. Now, this has been done to ensure that in the future, there's no issue relating to an absence of documentation, and a proper chain of documentation is available, so that maybe 10 years down the line, 10, 15 years down the line, an absence of documentation may not become an issue. Now, lastly, the Surrogacy Regulation Act, it has very strong inspection powers. Authorities have been given very strong inspection powers as well. So the appropriate authority under the Act, they are free to inspect surrogacy clinics, their equipment, whether they're maintaining records or not. All of this, they can do this without notice as long as it's done during working hours. And if they find that the clinic is actually not maintaining the standards under the Act, then the certificate of registration can also be cancelled. And if there is gross violation of the Act, then the people who are responsible for running the clinic, they can be subject to up to 5 years of imprisonment, and a fine of up to 10 lakh rupees can also be imposed in this case. So with this, we reach the conclusion of the Act. So to conclude, I would state that this Surrogacy Regulation Act as a whole, it's quite a detailed legislation. It's aimed at governing not only the intricate aspects of surrogacy, but also it's looking at safeguarding the rights and well-being of all parties who are actually involved in this transformative journey. Now, in the next segment of the webinar, we will be covering the investment-related aspects, because there's a lot of investments happening in India. And that will be covered by my colleague Himanshu. So over to you, Himanshu.
Thanks, Rahul. So India's healthcare sector has seen some serious foreign investment action since the early 2000s. We are talking about big money here, billions of dollars for hospitals and diagnostic centers, and also for drugs and pharmaceuticals. The net investment stood at around 71 billion in the fiscal year 22 to 2023 alone. And this kind of explains as to why India is one of the top 5 destinations for foreign investments in healthcare. But how does all this how does all of this investment magic happen? Well, it's thanks to some smart moves by the policymakers. They've been working hard to make Indian healthcare super attractive to the investors. So we've got the automatic route, which means no need to jump through the hoops. Investors can dive right in without needing prior permission from the Indian government. And then we have the approval route for those investments that need a prior government approval. And here's the kicker: each sector has its own investment cap, so which is like the limit of how much foreign investment is allowed. So if a sector isn't mentioned in the rules, it's assumed that 100% FDI is okay under the automatic rule. And when it comes to healthcare, there are two main types of investments: greenfield and brownfield. India's FDI policy heavily encourages greenfield investments, with the threshold set at 100% for the automatic route. And brownfield projects get automatic approval up to 74%, with additional government support required beyond that. Now, some notable investments would include when Nova IVF Fertility acquired a 51% stake in Southern Fertility. Uh, Kedara invested 50 million in Oasis Fertility, to name a few. So, in a nutshell, India's healthcare sector is a gold mine for foreign investors. The government is pulling out all the stops. They're setting up investment routes, sector specific caps, and encouraging both greenfield and brownfield investments. And it's clear that they're dead serious about making India a top notch spot for investments. And by welcoming foreign investors with open arms, India is gearing up to shake things up in its healthcare world. Now, I will hand it over to Renuka for a few closing remarks on our topic for today.
Thank you, Manshu. So, in this webinar, what we have attempted to cover is a very brief overview of the surrogacy laws in India as on date. As we discussed, there have been multiple developments within the last few months itself regarding surrogacy, and we expect a lot of change in the Surrogacy Act during the course of this year. But like we discussed in this webinar, while there have been positive developments introduced under the Surrogacy Act, some examples being now registration of surrogacy clinics is mandatory, even focus on informed consent is there now. There are still gaps in the Indian system that is yet to be addressed under surrogacy. For example, surrogacy by unmarried couples, same-sex couples, and so on. So while the regulators are attempting to make proactive and progressive changes to the Surrogacy Act, but because India has a diverse population and also there is rapid improvements within the medical field itself, the challenges to regulate this industry will always remain. And as concluding remarks, as India moves forward, it's imperative that the discussion and the advocacy efforts aimed at promoting transparency and ethical practices within surrogacy. That ends our webinar. Thank you so much for joining.